Good morning. Hi, I'm Megan Rhyne, and I am the Executive Director of the Virginia Coalition for Open Government. And this is our second Sunshine Week webinar.
Good morning.
And
Megan Rhyne.
today we're going to be covering the basics of records requesting. Yesterday, if you were interested, we did an update on the General Assembly bills that affected access that were introduced in the General Assembly and what happened to them, whether they passed, whether they failed, and what some of them that were sent to study in the FOIA Council. But like I said, today we're doing records basics, and tomorrow we're doing the basics of open meetings. Now, I don't know, I have no idea who's on this webinar or what your level of familiarity is with the statute. So I imagine a lot of this will be kind of basic, hence the name for some people, but hopefully, even if it is kind of basic, that this will be helpful and you can refer back to it if you need to. So I'm going to screen share most of the time, and we're going to just see the presentation. I'll check back in with you because who wants to look at me while we're doing this anyway? So let's get to our presentation. So before we get into the specifics of the statute, it's important to go to the policy statement that's at the beginning of FOIA. Now, FOIA may be unique among all statutes in Virginia that I know of in that it has a policy statement. So this statement is the General Assembly's notes on what the act is intended to do and how it should be interpreted. I like to think of it as the director's note on a script. Like, here are the words. Now let me tell you how those words should be interpreted. The strongest sentence in the policy statement, in my opinion, is this: the affairs of government are not intended to be conducted in an atmosphere of secrecy, since at all times the public is to be the beneficiary of any action taken at any level of government. The statement continues on, but for our purposes, the main highlights are that FOIA's procedures are to be construed liberally in favor of access, and its exemptions are to be construed conservatively or narrowly in favor of openness. These are important presumptions to keep in mind because also, unlike most statutes in the Virginia Code, FOIA anticipates that the requester and the government will have a conversation about these records. There are several instances in FOIA where a level of give and take is expected. So, getting into the specifics of the statute, for starters, FOIA applies to public records, those held by state and local government. Now, a record is pretty much any medium that you can think of, from a sticky note to a paragraph to email to recordings, handwritten notes, letters, I mean, even a chiseled rock, if that was what was used to conduct public business. Specifically, the definition of public record talks about records that are prepared or owned by or in the possession of a public body or its officers. That last, let me see. So right here, oops. Anyway, but that last phrase is really important because what it means is that a public record is a public record, even if it's sent and received from a private device or account, if it is about public business. The flip side of this is that if it doesn't have to do with public business, then it's not a public record, even if it's on a government-issued device or account. This is harder for people to understand now than I think it was maybe 20 years ago or 25 years ago, where, you know, if a government employee had gone home and taken her own paper and her own pens and her own envelope and her own stamp to write a report and mail it to her superior, no one would have questioned that was a public record, because it was about public business. And just because she used her own materials didn't somehow turn it into a non-public record. So that's what's going on when we talk about the difference between a public and a not public record, and how it doesn't matter whether it's the device or the account where it comes from. It has to do with whether it's about public business. So everyone, as of July 1st, 2017, every entity that's subject to FOIA now has to designate a FOIA officer. The requirement for a FOIA officer doesn't say anything about who that person should be or what kind of training he or she should have. It doesn't say whether or not, what kind of background they can have. It doesn't say whether that officer can have other job duties or job titles. It merely says that a FOIA officer must be designated and that the officer must receive annual training on FOIA. The training must be completed by the FOIA counsel or the government's attorney. VCOG offers training to government employees, but our training doesn't satisfy the statutory requirement for FOIA officers. On the other hand, we all know that more people than just the designated FOIA officer responds to FOIA requests and deals with FOIA requests. So that's why we continue to offer our training, because there are far more people than just the FOIA officer who are involved in the process and who both want and need this kind of training. But the statute is also silent on what role the FOIA officer should play in the overall request process. For one, as this flow chart shows, this is the organizational chart for, I believe it's the James City County government. But the point of the slide is to show that, government is organized, can be pretty complex and not the same from jurisdiction to jurisdiction. So it can't be expected for a citizen to know exactly where to go or who has dominion over various records. So that's why the FOIA officer is just to be a contact point. So that officer can also be the person who does absolutely everything in the FOIA process, or it might just be the person who makes sure that the request gets into the right hands. So maybe that like in this organizational chart, perhaps the officer gets the request, hands it off to, say, the Parks and Recreation Department, and then the people within that department fill the request. Or it could be that the FOIA officer receives the request, gets the records from someone else, and then responds to the requester. It's really totally up to the jurisdiction, the agency, the government entity, any of that. As a citizen, you just have to kind of do the best you can in figuring out then who it goes to. Though the FOIA officer is sort of the most reliable contact point, you're also not required as a requester to go to the FOIA officer, if that makes sense. So you could, as a requester, go straight to the Parks and Recreation Department to submit your request. They might send it back to the FOIA officer, who knows, but you're just, again, as a citizen requester, not required to know exactly who in government is going to have the records. You just have to give it a sort of your best shot. Now, when making a FOIA request, all the statute says is that you have to identify the records you want with reasonable specificity. So that essentially means that you have to identify the records as best you can so that the requester knows what he or she has to go look for. As long as they have a pretty good idea, that's really all the statute requires. There's nothing in the statute that says that the request has to be in writing, or that you use the words FOIA, Freedom of Information Act, or 2.2-3700. There's also nothing in FOIA that says you have to narrow your request. Now, sometimes you might be asked to narrow your request because the scope of what you've asked for is so broad that it would take forever to get the records to you, or once they did get the records to you, it would cost you an arm and a leg. But as far as the statute is concerned, there's no duty to narrow the request. Similarly, there is nothing in the statute that requires a requester to say who they're with, like a business or an advocacy group, or I'm a reporter. And there's nothing that requires a requester to say why he or she wants the records or what she's going to do with them. So these last points really can cause some discomfort. Really not required to be in writing? No, it's not required, but it is, of course, a best practice probably to put it into writing so that there are fewer misunderstandings about when a request was submitted and what exactly the request was seeking. If a requester makes let's say I made a request, I could do it orally, I could do it over the phone, and it's perfectly reasonable and acceptable for the government to put my request in writing itself. Just what can't happen is for the government to say, hey, unless you write it on our form, I'm not going to proceed with filling this request. It can't be a barrier to access. But it can also be uncomfortable for those in government to release records to someone they don't know or trust for whatever reason, or that they suspect will use the records to make them look bad or to embarrass them. Take, for instance, comments made in a newspaper column about 2 or 3 weeks ago where a police department said they didn't want to release body cam footage of a police stop to the driver's mother because they felt she had an anti-law enforcement agenda. And then they also said that they didn't want the video to be altered. Under FOIA, it shouldn't matter what a person's motivations are for asking for records. And that includes, see the little, person with the dollar signs around him. It includes when companies ask for records. And even if the government folks know that the requester is going to use these records to make money off of, it still isn't supposed to matter under FOIA. It makes a lot of people uncomfortable because they've put work into these records and now someone's going to take these and make money off them. But that's really not supposed to be a part of the FOIA equation. So as I mentioned when we were in the policy statement section, FOIA contemplates conversations about requests. And certainly the government can ask people why they want the records or who they are if it helps them to get what is really being sought. Why don't you, tell me what you're looking for so that I can better locate records that are responsive to your request. They just have to make sure that there's a fine line between this kind of discussion versus interrogation that leads to refusal just because you don't want to talk about it anymore. Once a request has been made, the government has 5 working days to give you one of the 5 allowable responses in FOIA. The response most people want to hear, including, I would say, government, because it gets the request off their desk, is here are all the records that you've asked for. And we love when that happens, and it happens more times than some folks want to acknowledge. It happens every day without incident. Here are the records, and it's a transaction without any hitch. A second response under the statute is that we are withholding some of the records you asked for and giving you others, or that we're giving you records and we're redacting portions of these records. A third response is that we're withholding all of the records that you've asked for. And a fourth response is that the records either don't exist or that they don't have them. So the government doesn't have to create a record that doesn't already exist just to respond to a FOIA request. But if the government doesn't have the records but knows who does, the statute actually says that they're supposed to tell you who has them. That's one of my favorite portions of FOIA. You know, hey, we don't have them, but we know who does. It's an unusual kind of requirement, I think, that's written into the statute. But finally, a fifth response is that the government needs an additional 7 working days to fill the request. There's been more than one court case that has said that any other response other than these 5 responses don't count. One court said it wasn't appropriate to say for the only response to be, hey, we have to check with the Transportation Safety Administration. That was actually the Supreme Court of Virginia that said, yeah, well, if that's your only response, that's not good enough. And there's a recent case just late last year from Norfolk that said the response asking for clarification wasn't one of those 5 allowable responses either. Now, the reason why that's important is because it can affect the deadlines by which the request is due. So if you're giving a response that's not one of these 5, the clock is still ticking. It doesn't stop the clock from ticking just because you've said, I need to check with Transportation Safety Administration, or I'm not sure what you're looking for. We need clarification. The clock is ticking, according to these 2 courts. Now, when we're talking about the clock ticking, we're talking about the 5 working day deadline. So keep in mind, so government has 5 working days to respond to your request. Now, that clock starts ticking the day after the government gets your request. And that's to prevent somebody from, going in at 4:59 on a Friday and saying, okay, well, there was your first day. So instead, if you submit your request on a Thursday, say the first day of the 5-day response window starts on Friday. The second day would be the following Monday. Unless Monday is a holiday, then it would be Tuesday. And unless Tuesday is the offices are closed because of snow, and then it would be Wednesday. But you get the picture. It doesn't count holidays, weekends, days that the offices are closed because of snow or something like that. Now, when the records are withheld or redacted, the denial has to tell you in writing the exemption or other law that allows it. There's also a requirement that if you're withholding the records, they're supposed to tell you sort of generally, how many and what kinds of records they are withholding, or how much data they're withholding. There's also a specific provision that says that a failure to respond to a FOIA request is considered a FOIA violation. But that same Norfolk court that talked about, allowable responses, that, asking for clarification wasn't one of the 5. that same court also said, yeah, that is a failure to respond, but it's a minimal one. And I'm still not quite sure what the difference between a violation and a minimal violation is, but that's what at least one court has said about the failure to respond within the correct number of days. So government is allowed to charge you for getting records. It allows government to recoup the actual cost, the quote, actual cost of searching for, accessing, duplicating, or supplying the records. So that can mean the hourly cost of the hourly rate of an employee's salary. It can include programming time from the, if you have an IT professional who has to be involved to retrieve old records. It can include review by the attorney. That part was kind of not agreed upon until the Virginia Supreme Court a couple of years ago in a case involving the University of Virginia said it was okay for that, that charge to be assessed. The cost, however, has to be reasonable, and it's also discretionary. That means that the government doesn't have to charge, but it can. It also means that, again, that it has to be reasonable, and so that it may not be reasonable for government to charge 15 hours of time for a routine, easy request. It also may not be reasonable to charge the hourly rate of an employee who makes, say, $120,000 a year versus someone who's making $40,000 a year, if that $40,000 a year employee is perfectly capable of filling the request. They might not be, but if they are, then it might not be reasonable to charge for the rate of a higher paid employee. Now, FOIA says that government must provide you with an estimate of the possible charges if a requester asks for it. FOIA also says, however, that if the request is expected to cost more than $200,000, goodness gracious, is expected to cost more than $200, government can ask the requester to pay a deposit of any amount over that $200. So if it ends up, though, being more ultimately, you would owe the balance. The requester would owe the balance. But if it ends up being less, then the government would owe you the difference. So all this, FOIA got sidetracked there. FOIA also says, though, that you have to stay current. The requester has to stay current with his or her bills. So that means that the government can hold off on filling any further requests until you've paid any bills that are 30 days past due. And not any bills, say you owe the water district something, you haven't paid your bill for the water district. That's not what we're talking about. We're only talking about for FOIA requests. And I mentioned that because I did see that at one point someone was charged, was refused, their FOIA request was refused because they hadn't paid a fee that was related to, I think they had a filing fee for running for elected office. Some states have what's known as a fee waiver, where journalists or requesters who are serving the public interest, that's the phrase, the public interest, can ask that any fees be waived. Now, because fees under Virginia's FOIA are discretionary, the government could waive the charges or charge at a reduced rate if it wants to, but it doesn't have to. That could be part of that conversation that FOIA anticipates. Now, but at first blush, this doesn't sound fair to Virginians. Why do they get a fee waiver in one of these other states if it's in the public interest? And that's what I'm doing too. But the flip side is that in order to get a fee waiver in those other states, you have to say why you want the records. You have to tell them what you're trying to do with them. So, and as noted above, in Virginia, it shouldn't matter who you are, what your status is, or what your reason for wanting the records, because there are no good reasons, but there are no bad reasons either. So, let's see here. Now, earlier I mentioned, of course, that one of the allowable responses is that the records are exempt by a provision of FOIA or that parts of record have been redacted. Now, the exemptions in FOIA, and there are somewhere in the neighborhood of 130 records exemptions, are discretionary and not mandatory, meaning the government may withhold the records under the exemption, but they don't have to. And they can choose to withhold them, but they're not prohibited from doing so under these FOIA exemptions. And I want to say a word real quickly about the fact that there are 130 records exemptions. That does sound like a lot. And it is. Most of these exemptions, though, you'll see are very narrowly drawn to specific agencies. The exemptions that sort of have these general application that a lot of people could use there are far fewer of these. I do hear a lot of folks who complain about the number of exemptions. There's too many, and I'm not going to dispute that. I wish there were fewer. And then sometimes frequently Florida is noticed for being very strong on access, and it is true. That's also true. Florida's law has over 1,000 exemptions. But again, theirs are very, very narrowly drawn. They're very narrowly drawn to specific agencies. So I guess my point is that you can't really tell too much about you can't tell too much about a law just by the number of exemptions there are. What matters more is the application of the existing exemptions and whether there is a culture of openness that supports a narrow interpretation of the exemptions. In Florida, for example, the right to know, the people's right to know, is written into the Constitution. So that shows right there that there is a different culture and expectation in Florida that might, even though 1,000 exemptions is crazy, it says that's why that state is known as a state that has better transparency laws, because it is part of a constitutionally based expectation of openness. So those are the exemptions, and like I said, those are discretionary. But FOIA also says that records may be withheld if other laws apply, and the other laws are strewn throughout the Virginia Code. Some may even be federally based, and they may actually prohibit release. So whether it's a discretionary exemption or a prohibition against release, those statutes have to be cited in writing to the requester when records are denied or redacted, relying on those laws. Now, when we're talking about redaction, we're talking about when a public record has, in one of two cases, either it has exempt or prohibited information and non-exempt information. That's like, say, there is information about a report that has been written, and it talks about the details of the report. Here's the report coming out, and it talks about issue A, B, C, and D. And then it goes on to say, Mary Jones created this report, and Mary's been doing a really good job. She's had a lot of difficulties in her personal life, but she's been really giving it her all here at work, and this report is an example of that. Well, that paragraph about Mary Jones could be considered a personnel record. And so you have this one record that has exempt material, Mary Jones's struggles at home, and non-exempt materials that says, here's this report and here's what it does. The other situation that you'll find with redaction is when a material, kind of related to the Mary Jones example, is if it has non-public information. So again, you could be talking about this report, here's this, and then you just happen to add in your message, oh, hey, did you see, were you watching the basketball games last night? Can you believe the upset of the number 1 seed by the number 16? It's never happened in history. Oh my gosh. That's all non-public information because it doesn't have to do with public business. And so that could be redacted. I say those two situations. There's a third when we're talking about very discrete pieces of information, like, say, a Social Security number or a financial account number. Those can be redacted as well. The statute refers to when information is exempt. And the reason it says information is because you're asking to evaluate the entire content of the record and whether certain information is exempt and certain information is not. If all of the information in the record is exempt, then the whole record's exempt. You don't have to redact everything in there except the page number. That does happen at the federal level, but the federal level has different procedural requirements. But in Virginia, we don't usually get those records that are completely blacked out except for the page number or the heading that has the name of the agency on it or something. Now, the exemptions in FOIA are grouped into 7 major categories, from those affecting specific agencies to those affecting all agencies. And in between are exemptions covering, things like public safety or trade secrets. So we'll get to those major categories and the most frequently used exemptions in a second. But here I like to mention, before you go searching for it in these exemptions, there's not a catch-all exemption for privacy. Some states do, and some states have a balancing test for privacy, but Virginia doesn't. You may find that there are, sort of bits and pieces of personal information exempted in various exemptions, and just 1 or 2 exemptions that have it. But there's no overarching privacy exemption that allows for names, addresses, phone numbers, or the like to be exempted or redacted. As I mentioned, in the redaction period, there is another law that requires redaction of at least some of a Social Security number. And there's an exemption for financial account numbers. There's an exemption for email addresses when you've signed up for some sort of like government alert. And there's cell phone numbers of first responders. I mean, things like that. But just not an overall exemption for privacy. That makes people, again, very uncomfortable, as Maria Everett, who used to be the director of the FOIA Council, used to say, that's the icky factor of having to release personal or names, addresses, phone numbers, but there's no exemption for it. So all of the major record category exemptions start with the prefix, just for our purposes, 2.2-3705. So 2.2-3705.1 refers to records applicable to all public bodies, like personnel records, attorney-client privilege, attorney work product records, etc. Point 2 refers to records related to public safety. Here will be records related to security plans or critical infrastructure and things like that. Point 3 covers records of administrative investigations, and we're going to talk about that in a second. Point 4 deals with educational records. Point 5 with health and social services records. And in this section, in point 5, you'll see a whole lot of cross-referencing to other parts of the Virginia Code. A lot of these cross-reference sections will then be mandatory prohibitions against release, but they're not written specifically into FOIA. Point 6 deals with proprietary records and trade secrets. And here, many of the exemptions will have what we call an earmarking provision. That's where, in order to get sort of the protection of this exemption, businesses have to, when they submit something that may be a trade secret, they have to give it to the government and say, hey, A, B, C, and D are trade secrets, and we don't want you to release them in response to a FOIA request. It also, though, gives the government, these earmarking provisions, gives government the ability to not necessarily accept that A, B, C, and D are all trade secrets. They may say, A, B, and C, that you're right. That's a trade secret, but D is the cost of how much you're going to charge for one of these. For some project that we're asking you to bid on, and we're not going to keep that as a trade secret. So you'll see, if you go to the statute, you'll see this section is really, really long because those earmarking provisions have been submitted, have been attached to many of those exemptions. Point 7 contains the agency-specific records, like the working papers exemption, which we'll get to. And then 2.2-3706 is the big section dealing with law enforcement records, from investigative records to what are known as non-criminal records, like officer disciplinary records. Now, you'll notice that in some exemptions, and particularly in the administrative investigations section that I mentioned, there's what I call a triggered release mechanism. So this would mean that a record that's exempt for one purpose may not be exempt for other purposes, or may not be exempt forever. So while an administrative investigation is ongoing, those records are off limits because we want to gather as much free flow of information to reach a result. But once the investigation is complete, a lot of those records then have to be released if requested. Also, similarly, records during a contract negotiation can be withheld because we don't want the government to have to tip their hand on their negotiating strategy. But once the contract is awarded, then those concerns aren't present anymore, and so those records can be released. So though I have no specific statistics to back this up, I'm basing this list of most common exemptions on my experience in fielding calls and inquiries over the years. So it seems that these 9, is this 9? 1, 2, 3, 4, 5, 6, 7, 8 exemptions tend to get, 9 if you count. It's 2 different ones. I got you. Are the most commonly cited when records are denied or redacted. So the personnel exemption is by far the most commonly cited, and that's for it's very broad. But it has also steadily grown over the years to include just about anything and everything that has to do with evaluation or performance of a job. Sometimes it's used in the course of releasing, say, it was tried to be used in the release of a report evaluating a response to an incident, and all the names in this were blacked out, even though these people had just been acting in their official duties. But usually it's sort of that HR component that we're talking about when we're talking about personnel records and the personnel exemption. Despite the exemption's breadth, though, that exemption also specifically says that salary information and reimbursements paid to an employee are not personnel records and have to be released if requested. So working our way down the list, why I couldn't decide if it was 8 or 9, is because I have 2 combined into one here. Legal advice, the attorney-client exemption, and then attorney work product exemption. So you've got the same kind of protections that any individual in the private, out in the world would have if seeking advice from an attorney is protected under these exemptions. The contract negotiation exemption is cited pretty regularly, as is the one that has to do with security of buildings. A lot of time, anytime someone asks about something that has to do with the building, this one gets cited, saying that, it might reveal certain security vulnerabilities that would allow someone to exploit them and do damage to the building. This scholastic records exemption is one that interacts with the Federal Family Educational and Rights Privacy Act, which is also known as FERPA. And it says pretty much anything that has to do with the academic life of a student is exempt. This section, however, because of the interaction with FERPA says, same thing, can't to release stuff having to do with their academic performance. But student directory information, their name, address, major, that sort of thing, that can be released. Then Virginia comes along and says, yeah, you can withhold it, though, under this exemption. And so that's where some of this disagreement has come over since November, when a voter registration group or progressive group sent text messages to college students asking for their cell phone numbers, and many of the colleges complied and gave it to them because it was allowed to be released under this exemption. And the group used it to send text messages saying, go register to vote, and while you're there, vote for the Democratic candidate. And that led to some legislative proposals that are still in flux. The governor hasn't signed them yet. But we'll see how that particular exemption changes after the signing period for the governor, excuse me. Economic development, especially when there's not been an announcement, but also records related to the retention of businesses or the trying to lure businesses to a particular area. The working papers, these last 2 exemptions are sort of the mother lode in that they're so broad. The working papers exemption says that working papers and correspondence of the named people can be withheld. Now, working papers are those papers and records that help a person reach a decision. So we want them to have access to lots of different options and opinions before making what we hope is the best decision. That part of the exemption isn't too problematic, but it can be an occasion. But it's really the last term, working papers and correspondence, that swallows the exemption whole. Because correspondence can be sort of anything that anybody writes or sends to the office or from the office. So who can use this exemption? Well, let's see. We have the governor, lieutenant governor, attorney general, members of the General Assembly, Division of Legislative Services, clerks of the House and Senate, the mayor or chief executive officer of any political subdivision. That means school board, local government, city, county, presidents of public colleges. And then when we get down even deeper, it says, okay, so who's in the governor's office? Who in the governor's office can use it? Well, the chief of staff, the governor's counsel, director of policy, the cabinet secretaries, the assistant to the governor for intergovernmental affairs, and those people the governor has delegated authority to. So that could be endless. And when we say members of the General Assembly, we mean not only those individual senators or delegates, but also their legislative aides when they're working on behalf of the member. So in other words, there are a whole lot of people making a whole lot of really important decisions who can use this exemption to really escape oversight, avoid oversight, I should say. Similarly, access to criminal records is really, really broad. Now, it can vary across the state, but the exemption, this section includes an exemption for criminal investigative records. There is nothing that says what is or isn't a criminal investigative record, so anything can be characterized as such. And once it is, the exemption goes on forever. It doesn't differentiate between open investigations versus those that have been closed for whatever reason because charges have been dismissed. It doesn't matter if the person's been convicted and served their sentence and maybe even died. This exemption can be used to withhold all current and former investigations. So it's just gigantic. Virginia has, we're nearing the end here. So if you're really, if you're wondering, Virginia has an interesting quirk that says it's only technically for Virginians or for media circulating or broadcasting in Virginia. So that would mean like the Washington Post or other media outlets that do business in Virginia. But citizens, even if they have owned property in Virginia or are part owners of a business or have a parent in a nursing home in Virginia or have been in the military and are stationed elsewhere but consider themselves Virginian, all of those things, technically the statute doesn't exist or doesn't have to respond to them. And this is even supported by a 9-0 decision by no less an authority than the United States Supreme Court. They have said this provision is okay. There are only 5 or 6 states in the country that have this provision. What it does, though, it means that a lot of people sort of are what we call scofflaws, where they can't get records because they're from, say, Kansas, but they find a friend or reporter or attorney or someone in Virginia to make the request for them. So you're finding people who have to do a workaround to get the records, but then they ultimately do get the records. The FOIA Council advises public bodies to go ahead and respond to them because of that, because the request isn't going to go away. It's just going to come back in a different form. The FOIA Council also points out that because they're not subject to FOIA, that if a request came from Kansas, then I guess you don't have to adhere to FOIA's timelines or FOIA's restrictions for requesting advance deposits or anything like that. But if they find someone to file it in Virginia, then you are subject to those same limitations. So sometimes it actually is in their best interest from a workflow perspective for government to respond to an out-of-state request. If there's been a violation suspected of these provisions, FOIA does allow for a writ of mandamus. So that's where you go to the court to ask the court to order the custodian of the records to release them. Injunctions typically apply to situations in meeting violations, but violations can result in civil penalties of between $500 and $2,000 for those violations that are considered willful or knowing. And I've been doing this for nearly 20 years, and I can still count on 2 hands the number of times I've ever seen civil penalties imposed. So judges really don't like to impose these, choosing to believe instead that these mistakes, are innocent and made, not willfully or knowingly. And hopefully you want that to be true. But those fines can be imposed by either a general district court or a circuit court. So if you want to get involved, I encourage you to attend FOIA Council meetings, to submit comments to the FOIA Council or the Supreme Court. That refers to developing rules. And it's actually, I shouldn't have included that part in this slide. And also to follow VCOG's newsletter, social media, and our monthly newsletter. So, VCOG relies on the support of its members. We have membership and donations, and we really appreciate that support. It allows us to do all of our work. We're a pretty bare bones organization, but we try to do a lot with what we have. And if you find things like this webinar or some of our other free services valuable, then you might consider giving to VCOG to support that work. So we've come to the end here. I don't see any questions down below, but you are encouraged to add them later, and I'll get back to them as I can. But otherwise, I appreciate you tuning in, and I hope you found this helpful. And have a good, sunny, sunshine week Wednesday. Thanks. Bye-bye.